Hello, and welcome to this MBL Seminars webinar called Crown Court Advocacy, Essential Tips for Your First Trial. My name's Clive Smith, and I'm a barrister, and I'll be taking you through today's course. Let's turn to have a look at today's course. And just want to say by way of introduction that today's course is very much an advocacy course. There are other courses, of course, that MBL provide, and indeed that I provide as well for MBL about jury trials, for example, in relation to juries, all those sorts of things. The difference between, for some of you who may have started off doing our magistrates court trials before dipping your toe or indeed plunging headfirst into doing your Crown Court trials. So we'll mention a little bit of law as we go through, but not too much. This is very much an advocacy course. And in saying that, I appreciate that equally some of you may even be doing your first ever criminal trial in the Crown Court. And if so, the best of luck to you. And so in terms of what we're going to be looking at today, first, of course, where to start. And of course, the challenge, and of course, such as this, is actually where to finish, because there's a lot of advice that I could impart to you, but I really want to deal with the basics and the foundations. We'll look at closing speeches, and you might think that's an odd place to start, but for reasons which will become apparent, that is exactly the right place to start. Then we're going to touch upon questioning witnesses, evidence in chief, talk a little bit about witness handling. I just want to give you a few pointers and tips, etc. And then I want to deal with points of law, because that's an issue that may well have come up in your advocacy already. But if you're in the magistrates court and you're taking that step into the Crown Court, the way in which these things are dealt with is slightly different. And just coming to terms with the way in which the Crown Court works is requires a little bit of adjustment, and a change of mindset really is the best way I can describe it. And then, of course, it wouldn't be an advocacy course if I didn't give you some advocacy tips. And, of course, very importantly, how to deal with any difficulties or issues you may have with your case. And then we're going to finish off with how to, I've put in quote unquote, give a little evidence, because, of course, you may be frowning. You're thinking, Clive, I'm an advocate. How could I possibly give evidence at trial? Well, of course, you can't. But there are ways around that. And that, of course, is the art of the advocate. And I'll give you a few tips and suggestions as to how you might help your case in terms of providing some assistance to the court. And then finally, we'll just touch upon adverse inferences, because that's a point that will come up in many trials, either as a result of your client's failure to give evidence, or, of course, their failure to give account in interview, or, of course, they may have given an account in interview and they may have now changed that account. And you may have to deal with a Lucas direction. We're not going to deal with that specifically today, but a Lucas direction is in relation to lies. So if the judge asks you if your client has lied, whether you're asking for a Lucas direction, the answer to that question is probably yes. Okay, so there we are. That's what we're going to be looking at today.